Good morning, this is your Kelso Report for Wednesday, September 14th, and I'm your host, Clark Kelso. One of the most important questions in the relationship between a union and an employer is whether a particular subject matter is subject to bargaining. The duty to bargain in good faith to agreement or impasse over matters that are subject to bargaining is the cornerstone of our labor law. In local Joint Executive Board of Las Vegas versus NLRB, the Ninth Circuit faced this question in a 15-year-old dispute between the Culinary Workers Union and Bartenders Union in Las Vegas and their employers, over the question of whether the employers could unilaterally terminate the union dues checkoff program in a right-to-work state, Nevada, without taking that issue into bargaining. The unions and employers have been trying to negotiate a new contract back in the early 1990s. But time ultimately ran out, and their collective bargaining agreement expired. For a few months, the employers continued to deduct union dues from workers' paychecks pursuant to a contract provision, notwithstanding the expiration of the collective bargaining agreement. But then in June of 1995, the employers informed the unions that they intended to cease checking off dues, and shortly thereafter, the employers actually stopped deducting dues from employees' paychecks. The unions filed unfair labor practice charges against the employers, alleging that the cessation of dues checkoffs violated the unilateral change doctrine under NLRB versus Katz, the Supreme Court decision from 1962. The employers took the position that under well-established NLRB precedents, starting with the 1962 decision in Bethlehem Steel, an employer's obligation to continue a dues checkoff arrangement expires with the contract that created the obligation. It was a special exception to the unilateral change doctrine. The NLRB agreed and dismissed the complaint 11 years ago. It noted that although Bethlehem Steel had itself arisen in the context of a contract that contained both union security and dues checkoff provisions, the decision had subsequently been expanded by the NLRB so that even absent a union security provision in a right-to-work state, a dues checkoff clause terminates at contract expiration. Well, the Ninth Circuit reversed the board's decision in 2002, concluding that, quote, "We are unable to discern the board's rationale for excluding dues checkoff from the unilateral change doctrine in the absence of union security," close quote. The court rejected the NLRB's explanation that the rule of Bethlehem Steel had simply been expanded in subsequent decisions, albeit without much explanation, to encompass dues checkoffs absent union security, and that there was now a line of NLRB decisions restating that expanded rule. Now, rather remarkably, in my opinion, the Ninth Circuit rejected the NLRB's contention that 40 years of applying that rule consistently was an insufficient basis for continuing to apply the rule. The Ninth Circuit remanded, quote, "so that the board could either articulate a reasoned explanation for its rule or adopt a different rule with a reasoned explanation to support it," close quote. Well, obviously frustrated with the Ninth Circuit, the NLRB tried again in 2007, this time concluding that the collective bargaining agreement contained an express waiver of the right to continue dues checkoff past the expiration of the agreement. The Ninth Circuit reversed again, this time concluding that there was, quote, "simply no clear and unmistakable waiver," close quote, in the evidence. They remanded again. Third time around, and the NLRB got hung up because one of its 5 members recused, leaving the board with only 4 members who, you guessed it, split 2-2. The best the board could do in this circumstance was to reiterate unanimously that the precedents in Bethlehem Steel and its progeny actually did compel the conclusion that the employers did not violate the NLRA by unilaterally ceasing dues checkoff. Well, for the Ninth Circuit, it was 3 strikes and you're out. The court and the NLRB had themselves reached an impasse. Instead of remanding again to the NLRB, which might well hang again in a 2-2 decision, the Ninth Circuit engaged in its own analysis of the issue, essentially substituting its judgment for that of the NLRB. And the court concluded that a dues checkoff provision in a contract without a union security provision did not terminate with the expiration of the collective bargaining agreement, and therefore the employers could not unilaterally cancel the provision. Well, I'll tell you, this case looks to me like a likely candidate for Supreme Court review. In all three of its decisions, the Ninth Circuit appears to have failed to pay sufficient deference to the decision-making authority of the NLRB. And in the third case, the court clearly stepped into the NLRB's policy-making and decision-making role. The best thing that you can say about the Ninth Circuit's decision here is that a 15-year-old labor dispute has perhaps been put to rest. But after 15 years of fighting, my guess is the employers are not about to walk away without seeking further in-bank or Supreme Court review. And now our one-liners. First, a First Amendment case. In Johnson versus Poway United School District, Unified School District, the Ninth Circuit held that summary judgment should be granted to a school district, which ordered a high school calculus teacher to stop using class time to talk about his views on God, our nation's history, or God's role in our nation's history, and to take down several large banners in his math classroom that read, "In God we trust," "One nation under God," "God bless America," and "God shed his grace on thee." You get the theme of things. The teacher challenged the orders from the school district under the Free Speech Clause, Establishment Clause, and Equal Protection Clause. The district court granted summary judgment to the teacher after analyzing the issue using standard forum-based First Amendment analysis, where the court concluded that a classroom was a limited-purpose public forum. The Ninth Circuit reversed, holding that forum-based analysis was inappropriate, and that the case should be analyzed under the analysis set forth in Pickering versus Board of Education, which gives the state as an employer greater power to regulate the speech of its employees. After conducting that analysis, the Ninth Circuit concluded as a matter of law that because the speech at issue owes its existence to the plaintiff's position as a teacher, the district acted well within constitutional limits in ordering the teacher not to speak in a manner it did not desire. Next, we have a civil procedure case involving informa pauperis. In Moore versus Maricopa County Sheriff's Office, the Ninth Circuit reversed a district court's decision to deny a prisoner informa pauperis status. The district court had found the prisoner had filed 4 prior actions that counted as strikes under the statute governing informa pauperis filings. According to the statute, if a prisoner bringing a civil rights action has 3 or more prior actions that have been dismissed as frivolous or malicious, or for failure to state a claim upon which relief may be granted, then the prisoner is denied informa pauperis status unless the prisoner is under imminent danger of serious physical injury. The Ninth Circuit reversed because 2 of the 4 prior actions had actually been dismissed for lack of subject matter jurisdiction, not for failure to state a claim for relief. Following other circuits, the Ninth Circuit concluded that the statute meant exactly what it said, and that it should not be broadened to encompass claims dismissed for lack of subject matter jurisdiction. Congress is, of course, free to broaden the statute if it so desires. Next, an interesting double jeopardy problem. In United States versus Alvarez Moreno, the Ninth Circuit confronted a really interesting problem when the defendant's counsel told the court in pretrial proceedings that the defendant was ready to go to trial before the court and to waive the jury. But the defendant never filed the proper waiver forms, and the court never properly questioned the defendant personally about the decision to waive the jury. After his conviction by the court, defendant filed a motion to set aside verdict by trial court. Trying to correct its legal error without triggering a double jeopardy problem, the court construed the motion to set aside as a motion for new trial, which it granted. Defendant then moved to vacate the new trial order on the ground that a new trial may be ordered only on defendant's motion, and defendant had not made such a motion. The trial court then denied the motion to vacate, and before the second trial could begin, the defendant filed an appeal on double jeopardy grounds. Finding no traditional basis for avoiding double jeopardy, for example, a successful appeal from the conviction, a validly declared mistrial, or a properly granted motion for new trial, the Ninth Circuit cut through the procedural haze and remanded to the district court with instructions to set aside the new trial order and deny the defendant's motion to set aside the verdict on the grounds that the motion cited no rule or authority to support it, and the motion to set aside the verdict was procedurally improper. By this tactic, if the defendant wanted to challenge the failure to secure a proper waiver of the right to jury trial, the defendant would have to appeal the conviction. And then, if successful on appeal, a traditional exception to double jeopardy would apply. As the court noted in a footnote, better, in our view, to engage in a little formalism now to avoid a bigger quagmire in the future. Next, we have a couple of abstention cases. In E.T. versus Cantil Sakaue, the Ninth Circuit affirmed the district court's decision to abstain in a suit challenging the constitutionality of the Sacramento County Dependency Court. The suit alleged that both caseloads for the court and caseloads for court-appointed attorneys are so excessive as to violate federal and state constitutional and statutory provisions. Well, the Ninth Circuit agreed that the trial court should abstain, pursuant to the Supreme Court's decision in O'Shea versus Littleton in 1974, which is based on the Younger abstention doctrine. According to O'Shea, federal courts should not entertain actions that seek in effect to impose an ongoing federal audit of state court proceedings. Abstention was appropriate in this case because the challenges to the juvenile dependency court system would necessarily require the federal court to intrude upon the state's administration of its own court system. We had a second abstention case yesterday, this one involving Younger abstention. In Potrero Hills Landfill versus County of Solano, the Ninth Circuit held that Younger abstention did not apply in a suit challenging the constitutionality of a local ordinance regarding importation of out-of-county solid waste, where two pending state court actions to compel enforcement of the ordinance had been brought solely by private parties. Now, Younger abstention generally applies to state criminal or civil proceedings which, 1, are ongoing, 2, implicate important state interests, 3, provide an adequate opportunity to raise federal questions, and 4, as a practical matter, would have the effect of enjoining the state proceedings. The Ninth Circuit held that because the two pending mandamus actions in state court seeking to enforce the ordinance had been brought by private individuals, there was not a sufficiently important state interest with which the federal litigation would interfere. The generalized interest in having state courts adjudicate cases is insufficient by itself to trigger Younger abstention. And absent any pending cases brought by government officials to secure enforcement, the Ninth Circuit concluded that Younger abstention did not apply. The court remanded to the district court to consider whether a different form of abstention, known as Pullman abstention, may apply, since the case is probably going to involve difficult and novel interpretations of local and state law, which is the focus of the Pullman abstention doctrine. Next, a banking law case, again involving one of those foreclosure problems. In Calvo versus HSBC Bank, the Second District rejected a homeowner's attempt to challenge a foreclosure sale on grounds that the bank had initiated foreclosure proceedings under the deed of trust without any recordation of the assignment of the deed of trust in violation of Civil Code Section 2932.5. The court rejected the complaint because the recordation statute had been uniformly interpreted over a 100-year period as applying only to mortgages and not to deeds of trust. In the deed of trust context, a different statute expressly authorizes foreclosure initiation irrespective of the recording of a substitution of trustee. Accordingly, MERS, the nominal beneficiary and an agent of the original lender and also of the defendant bank, had the power to initiate the foreclosure process. And that's it for today's Kelso Report. Have a great day in the law.